Thank you. Have a seat. Good morning. This is CV 2016-091991. It's time set for the initial return hearing on the OSC request by plaintiff. Let's get appearances first, please.
Good morning, Your Honor. Joshua Bull on behalf of Terravita Country Club.
Okay. Your name, please?
My name is Anita Bell.
Okay. And your name, sir?
My name is William M. Brown, Your Honor.
Okay. So have you had a chance to visit and try to work anything out?
I have not, Your Honor.
Okay. So what's holding this up from getting it resolved? I don't understand.
Nothing at this point, Your Honor. Unfortunately, before this motion to dismiss was filed, the association on a number of opportunities had requested that a deed be provided to the association or some form of written representation. Despite our numerous requests, that never happened up until it was supplied in the motion to dismiss. Now that we have that information, Mr. Brown is on the deed. This case is now moot.
Okay.
We don't think there's any need for any further proceedings. We wouldn't be here but for the failure to give that to us. But now that we have it, we don't see any need to go forward, and we are agreeable to dismiss this case.
All right. Is that agreed?
May I be heard, Your Honor?
Okay.
In fact, what counsel says is in part correct. That information was provided to the association in January of 2014 and continuously during that period of time prior to them filing a lawsuit. So it's to gloss over to suggest that I was recalcitrant of not providing them whatever documentation they request. There is no requirement in the association's governing document. There's no requirement in the statute that I provided to them. And I did attempt to enlighten them, and they chose not to ignore it. It is a conduct that is pervasive. There are two.
There's nothing. I appreciate your position and you want to be heard, but there's nothing in front of me now. He's moving to dismiss the case.
Okay.
I need Ms. Bell to indicate, since you're the party in this case, do you object to the motion to his request to dismiss the case?
I'm sorry, Your Honor. I'm having difficulty hearing you.
He's asked to dismiss. He's going to dismiss his case, which actually he's entitled to do. There hasn't been a responsive pleading. I guess there's been a motion to dismiss filed. So he's asked to dismiss the case, which would make your motion moot. We don't have to hear anything, and you all are free to go. So basically, you've won without a hearing, okay? But the case gets dismissed.
Your Honor, may I have my taxable costs incurred in doing this?
Okay, in filing the motion to dismiss, did you file some costs?
Yes, I did.
I don't know if you did or not. You're shaking your head.
There would be no cost filed with the motion to dismiss, Your Honor.
Okay. I don't know. Did you have to file something?
Yes, sir, I did.
What did you pay?
$237 for the filing plus of the copies for 6 sets of copies.
Okay. Are you agreeable to that? If that's
No, Your Honor. Again,
Okay.
none of this would have been necessary but for the gamesmanship that was played here. This lawsuit would not have been necessary.
Okay. Well, why don't you just agree to walk away and make this thing go away? You guys are fighting over stuff that, I mean, you can file a statement of costs and see what happens. But right now he's moving to dismiss his case, and you're in a situation where you've won. If you're going to make me hear discussion on the merits about a dispute that precedes this courthouse, that's really not what we're here for. I'm trying to encourage you to get this thing settled. So basically they're just proposing a walk away. They're now going to accept the documentation that you provided with your motion. I don't know why that wasn't provided earlier either. You said that they somehow could have gotten information about that way back in 2014. Maybe that's true. I'm not here to decide that today. That's not what today's hearing was about. Today's hearing was to decide whether we were going to put a schedule in place to hear your motion to dismiss and to hear their request for an injunction. And right now there's no case pending because they want to dismiss it. So if you think you're entitled to costs, you can file a request for costs. You'll have to do it in writing and you'll have to support it. And then I'll have to rule on it. But I'm going to grant their motion to dismiss. So whether you get costs or not is up to you. If you're going to file something, you can do that. Do you want to do that, or are you willing to just walk away and have this thing settled, which is what we prefer, of course. As a court, we prefer people settle cases.
Your Honor, I think, forgive me, I'm upset this morning. I will be 64 years old in 2 months, and this the first time in my life I had any opportunity to be a defendant. I've never even had as much as a speeding ticket.
Right.
It's not because I just...
This is a civil matter, though. I want you to understand this is a civil matter, and now they're withdrawing their complaint, so you're not a defendant. That's the good news, okay? I know it's traumatic to have your name on a piece of paper. It's a civil matter. It's not a criminal matter. It doesn't mean you're a bad person or you did something wrong. They made an allegation that they're now withdrawing because of the information you provided in your motion. And they're...
Why didn't they pay attention to it in 2014 when I mailed it to them?
I don't know. They're saying when they asked you by letter to provide information, you didn't give it to them then. Why did you wait to file a motion to dismiss? Why didn't you give it to them earlier? So you guys can go back and forth about your communication gap, which is obvious. That's why you're here. Where right now you've got a settlement. You've got what you want. He's going to be able to speak at the meetings, and you can go forward with your lives and not have this spot hanging over your head anymore, and not having this controversy with the club. I mean, I think that's a good thing. That's a win for you. That's how I'm viewing it. That's what's going to happen. Are you willing to waive your request for costs?
Can I waive that?
You can, yes.
May I reserve my right?
I'll tell you what, I'll give you 2 weeks to decide. Okay, I'm going to give you a deadline. And your deadline will be, let's see, today is the 24th. So if we go out 2 weeks, that would be June 7th. So by June 7th, if you're going to file a request for costs, you need to file it in writing. You need to provide the other side with a copy so they have an opportunity to object to it. And you'll have to have sufficient legal grounds to be awarded costs. And you might be. I'm not here to say you will or you won't. I've been encouraging you to try to settle it today, to just have a walk away and be done with it. Because if you ask for costs, they're going to oppose it, and then we're going to have a big discussion again, and this is going to continue to hang over your head. Okay? That's up to you. If you want that extra stress in your life, that's what you're going to get for your $200 and some. A lot more stress than $200. Okay? But that's your choice. I've given you 2 weeks to decide. All right. So for now, we're going to go ahead and dismiss the case without prejudice. You want it with prejudice? Do you care?
Without prejudice.
I'll make it without prejudice since there's been no ruling by the court on the merits. And just show that counsel has withdrawn his complaint. So it'll be dismissed without prejudice. And I've given the defense 2 weeks to file a request for costs if they decide to do so. Otherwise, the matter will be dismissed. Well, it's going to be dismissed. It's just a matter of whether costs are going to be considered or not. Okay? So, again, I encourage you to try to go on your way and try to put this behind you, but that's your decision. Okay? All right. Thank you.
Your Honor, just one last comment. We too wish this wasn't necessary.
All right. Well, I appreciate that. So hopefully you guys can move forward now, and I know you're chuckling, and I hope that things can get better for you at the club as well so that you don't have to worry about this stuff anymore. Okay?
Since they filed their lawsuit, they have denied me the second time books and records. This will not end with the settlement of this case.
Well, you'll see. You know, he's made some representations in court, and we'll see. As long as you're honoring your end, and the club should be honoring theirs. Now that they have the documentation, I don't see why it should be a problem anymore.
That's absolutely correct, Your Honor.
Okay? So, we'll see.